Okay, good morning, everyone. I'm Mahwash, Communications Counsel at LAWPRO. We're very excited that you're here with us today, either in person or via webcast. We have over 100 people viewing the webcast today, so welcome everybody. This program qualifies for 40 minutes of professionalism and 30 minutes of substantive. It also qualifies for the LAWPRO Risk Management Credit. So visit www.lawpro.ca/rmcredit to find out how to claim that credit. Feel free to submit questions. I'll answer them at the end of the program. And for those who are viewing on the webcast, for any tech issues, please email support@oba.org. So what is slides to start with, right? First, we scare you. Well, fear is not just a monster under the bed. This kind of fear is a productive fear. So hopefully trigger you into some positive action. Real estate continues to be the second largest LAWPRO claims area by cost and by count. And you can see the largest piece of the pie on the slide there is communications, and that's 41%, and that's a significant number. Breakdown in lawyer-client communication is the most common cause of real estate claims, and we often hear about top 3 mistakes that lawyer makes. 1, the lawyer didn't communicate. 2, the lawyer didn't communicate. And can you guess the third one? The lawyer didn't communicate. So you can manage that risk by really providing good communication, keeping good communication open with your client and providing them with a roadmap sort of at the outset of the retainer so they know exactly what to expect. And you can manage their expectations that way. And this is why we're here today. We're here to help you. We're here to help you practice better, to avoid malpractice claims, and my ultimate goal here today is that you retain some or all of this information, and one day down the line when you're going to be completing that real estate transaction, a light bulb's going to go on and you're like, oh yeah, I remember this. What did she say will help me not get sued? Communicate. So a bit of the agenda for today, I'm going to be talking about file management, communication, important dates. I'm going to be talking about some transaction basics, important practice stuff. Of course, we're going to be talking about fraud, and then I'm going to be giving you some resources to tap into and take home. So even the most routine real estate transactions involve so many steps that it's really easy to let one or two slip through the cracks. So an intake form or a file checklist can be a really valuable risk management tool. It can help you keep on track and also enable effective communication with your clients. So if you don't already use a checklist, I've actually created one for you. It's in the back of your materials. It's a really great resource, so do take a look at that. Some document production software also contain checklists so you don't miss important details. And this type of software also generates closing documents for you based on some really initial input. Most of these softwares are available to use 24/7, and so you can work on documents at a time and place that's convenient for you. Some of the questions to include in your intake form are how the purchasers intend to take title, the residency of the purchaser. For example, if the purchaser is a non-resident, ask if they're going to be in town for the closing, and if not, make sure you get a power of attorney. Also, at this point, you should raise the non-resident speculation tax, which is a new tax, but you should definitely look into that as well. Find out if there are any tenants, the number of residential units. The purchaser's intention about the future use of the property is also an important one to find out at the beginning of the retainer. We're going to discuss that a little bit more in detail later. So as you can see, a checklist will be important for that part of the transaction as well. As soon as you can, after you've reviewed the statement of adjustments from the seller's lawyer, inform the clients about the money that they will need to close the transaction. And some of the items include your legal fees, any estimated disbursements, title insurance, registration costs, etc. If you don't expect to get the statements of adjustments just before closing, then don't wait until the last minute. Bring the estimate up earlier with your client. There are 2 things mostly that a purchaser is going to be concerned about: buying that dream home and how much it's going to cost them. So giving them sort of an idea of costs early on is a really good idea. So these are some of the steps in just one transaction. So you can see there's so many steps to complete. Again, use a checklist. If you have 2 or 3 transactions closing on one day, a checklist can be really helpful here. You're going to be reviewing the agreement of purchase and sale. You're going to be flagging important dates. You're going to be sending out initial letters to clients, the seller's lawyer. You're going to be doing your due diligence, sending requisition letters, also preparing the mortgage documents, ordering title insurance, like the list really goes on. So again, it's really important to have a checklist, and I'm going to walk you through all of these in detail. So the standard agreement of purchase and sale form used in Ontario for most residential real estate transactions is the AREA form. The agreement of purchase and sale is a contract between the seller and the purchaser. It sets out the rights and responsibilities of the parties, the price of the property, and any terms and conditions. So it's very important as a real estate lawyer to be deeply familiar with this purchase agreement, but also its preset clauses. However, no 2 agreements are the same, so you do have to pay attention to any schedules that might be attached. Most of the time, you're going to receive the agreement of purchase and sale when it's already final, when it's firm. So you won't actually get any opportunity to provide advice on the agreement of purchase and sale or draft it. However, if you do get that opportunity, then that's a completely different retainer. So I'm going to talk about some of the key components of the agreement of purchase and sale. By the way, there was a Law Society program on May 10th called the Annotated Agreement of Purchase and Sale. A really good program, goes into a lot of details about all the specific clauses. So if you do get a chance, it's an on-demand video now. If you get a chance and if you want to really go into detail, watch that program. So the parties must be identified correctly. And if one of the parties is a corporation, then it's important that the appropriate person has signed the agreement on behalf of the corporation. Also important is to confirm the municipal address with your client, and as well as the lot and plan if possible. I want to make a note about the purchase price, and you probably already know this, that if there have been a lot of counter offers, the purchase agreement has been faxed back and forth a number of times. By the time you get it, you probably can't even read the purchase price, right? I see some nodding there. That's right. So it's really important to confirm what the purchase price is with your clients and also with the seller's lawyer. 99% of the time, the deposit will be held in trust by the listing agent, and there's a basic rule around deposits. If the purchaser defaults, the seller gets to keep the deposit. The seller gets to keep it even if there's actually been no damages. And vice versa, if the seller defaults, the purchaser will get the deposit back. Irrevocability is the time within which the offer is open for acceptance. If it's not accepted within that time, then the offer has become void. Also, keep in mind that if there's been a counter offer, the irrevocable date has changed. A tip, as soon as the agreement of purchase and sale comes through the door, make sure that you look at the closing date to check that it's not actually closing on a weekend or a statutory holiday, because mistakes do happen. Sometimes people will just put in a date without realizing it's a holiday or a weekend. So make sure that if that's the case, try and get an amendment as soon as possible. You will also note that it says 6 p.m. on the agreement of purchase and sale, even though you can only register till 5 p.m. Well, the seller has until 6 p.m. to gather all their belongings and provide vacant possession. So it's also a good idea to make your purchaser clients aware of that. For example, if they're waiting outside the door and it's 5 p.m. and they think, oh, 5 p.m. is the deadline, they can get a little annoyed. So you can manage that expectation by sort of telling them, the seller does have until 6 p.m. To leave the property. Also, as a side note, since July 2015, the title search section, the requisition date is listed, and it's the date by which the purchaser's lawyer needs to examine title to the property and submit a letter to the seller's lawyer with a list of issues that may require some sort of a response or a solution. If the requisition date has passed by the time you get the agreement in your hands, then it would be prudent to attempt to get sort of an amendment. However, if the agreement is silent on a requisition date, then you have a 30-day time period. Also, just note that matters that go to the root of title, such as a Planning Act issue, you can actually raise that after the requisition date. So the title section sets out that the purchaser is entitled to good and clear title, subject to restrictions and covenants that run with the land provided they've been complied with. And also subject to any municipal utility easements and other easements such as phone, cable, drainage, etc., which do not materially affect the use of the property. Explain easements to clients. They don't know what that is. So it's a really good idea to take some time to explain this to clients. Also note that under this section, there's a provision that allows to remedy a situation by actually giving title insurance as a fix. A quick note about construction liens. Although there's no specific provisions dealing with construction liens in the Agreement of Purchase and Sale, if you see it on title, you must requisition its removal. A registered construction lien is a breach of the seller's promise to convey title free of encumbrances. So the closing arrangements section, the process is set out in the Agreement of Purchase and Sale, and it refers to the Law Society's Document Registration Agreement. I'm going to discuss the DRA a little bit more in detail later. The Discharges and Production of Documents section, as stipulated, the seller needs to provide to the purchaser any title documents or any surveys of the property that are in possession of the seller. Oftentimes, the seller will not have a survey, but it's important to know that a PIN map is not a survey, right? It doesn't list, it doesn't show the buildings, it doesn't show the boundaries, so don't rely on that as a survey. There's a really great website, if you want to make a note of that, is www.landsurveys.com. It actually contains some surveys that you can look at. More important, if the seller has one or more outstanding mortgages that are not being assumed by the purchaser, the seller needs to provide, one, a payout statement from the mortgagee, a direction executed by the seller's lawyer directing funds to pay out that mortgage, and a solicitor's undertaking to discharge the mortgage after closing. So there's 3 items, if there is a mortgage, that you need to obtain from the seller. However, just a note about private mortgages. A private mortgage needs to be discharged on or before closing. You should not be closing a deal with a private mortgage not being discharged at that time. Also, the Law Society strongly recommends not to pay discharge funds to the seller's lawyer in trust, but to pay to the lender directly. So it is not recommended that you give the discharge funds to the seller's lawyer. So a really quick note about Planning Act. There is a remedial preservation clause, if you will, under this section. The agreement is effective to create an interest in the property only if the seller complies with the subdivision control of the Planning Act. So this gives the party sort of an opportunity to cure a problem, either by obtaining a consent or other resolution before closing. I'll talk briefly about Planning Act later on as well. It's important to confirm the residency of the seller and to obtain a statutory declaration from the seller that they are not non-residents, since there are tax implications. If you or the purchaser is aware that the seller is a non-resident and a clearance certificate from CRA is not available, then you must ensure compliance with the holdback requirements of Section 116 of the income tax. That's very important. There are some CRA bulletins, so you can Google that and get some more information. So finally, schedules. Once they're added to the Agreement of Purchase and Sale, they do become part of the contract, so do pay attention to the schedules. In fact, depending on the wording, schedules can actually supersede the Agreement of Purchase and Sale, so you should be careful there. In normal markets, the most common conditions you'll see are conditions on finance or inspections, not so much in a hot market, but most conditions are in the purchaser's favor and waivable by the purchaser. So the purchaser will have to do something to waive that condition, so make sure that you pay attention to that as well. So as soon as the deal comes through the door, the clock starts ticking and time is of the essence. Time being of the essence is actually stipulated in the Agreement of Purchase and Sale as well. So if for any reason you are getting an amendment of the date, restate the time is of the essence. That's very important. Flag certain dates immediately. If you use a tickler system, really good idea to either use some sort of a tickler system, or if you just use your calendar and you set up reminders on your calendar, really good idea to flag these types of dates. So the closing date, the requisition date, and the due diligence period leading up to the requisition date, Some mortgage-related dates, such as the request for funds, that's a really important one. And after closing, follow up with the seller's lawyer on any mortgage discharges. Typically, that will happen, a mortgage will be discharged within 30 to 60 days after closing. So lots of arrows going to that 41%, right? Because I want to just drive it home. Remember the biggest piece of the pie, communication? Well, an initial letter or a retainer letter to the client can be a great way to outline how the matter will proceed. You can provide the clients with some guidelines if needed and boundaries on what you will be doing and what you won't be doing and what you expect the clients to do. For example, what the client's responsibility is, such as setting up home insurance, obtaining a fire insurance binder, mortgage instructions, getting those over to you, setting up utilities. So these are all sort of minor things, but really important for the client to know about that it's their responsibility. You're actually not doing everything for them. So your retainer letter is essentially a disclosure document. So communication isn't just important at the outset, but throughout the transaction as well. Make sure you keep the clients in the loop. If there are any issues that come up, definitely have a conversation with the client and get instructions on how to proceed and document all instructions and communications in writing. As you complete the title and off-title searches, you may come across easements, restrictive covenants, encroachments, etc. that you should disclose to the clients. And if appropriate, you can explain that under the agreement of purchase and sale, there's a requirement that they actually accept some of these issues. Also, don't forget the lender-client, right? Remember that in most real estate transactions, the purchaser as borrower and the lender are your clients. So let the purchasers know that matters relating to the deal cannot be kept confidential from the lender. And ask yourself, is there information material to the lender's decision to advance funds under the mortgage that is important for the lender to know about? And communicate that to the lender. So some examples include an inflated purchase price, unusual changes in property value, the deposits not being held by the listing agent or lawyer, or information that suggests that the purchaser is misrepresenting the true circumstances of the purchase. So title searching is, I definitely think it's the tricky stuff, and this section really needs a CPD program on its own. In fact, there are programs out there which I recommend you go take a look at. There are various parts, and we're going to cover some basic concepts. So you're going to be reviewing the parcel register and the instruments. You're going to be doing some off-title searches, and you're going to be doing the executions or writ searches. So title search is conducted using Teraview. There are 2 land registry systems in Ontario. As you know, there's land titles and registry. Most properties in Ontario are in land titles, and last I heard there are about 30 to 35,000 properties left in registry that have not yet been converted. So if you see that R next to the PIN number on the parcel register, it indicates that the property is in registry and that defects have been found leading to its non-conversion. So really good idea to contact the land registry office to determine what these reasons are. It could be a Planning Act issue, an easement issue, or a description issue. So today we're going to focus on land titles. And as you know, they were converted by the Ontario government, and all relevant instruments are going to be on the parcel register. However, title searching is not that simple, right? You have to not only look at the parcel register, you need to pull the instruments and have a look at them. You must always obtain a parcel register with deleted instruments too. You know, you can check that box with deleted instruments. Always get the deleted instruments. Why? To gauge for suspicious activity, right? So there could be some frequent or recent transfers or discharges, and that's sort of a red flag. So you should definitely pull the parcel with deleted instruments. The agreement will usually contain the legal description. If it's incomplete, you can search by the seller's name and find the PIN. Also remember that sometimes a property comprises of more than one PIN, so be very careful and make sure that you're conveying 2 PINs if there's 2 PINs attached to the property. Once you have the parcel register, make sure that the legal description at the top of the parcel register matches what's in the agreement of purchase and sale, and discuss that with your client as well. So again, to recap, for a fulsome title search, you should review all the instruments and determine their effects as well. For example, easements or restricted covenants, rights of way that you should bring to your client's attention. If the legal description has a subject to interest or instrument, the notation must be removed before closing unless it's an easement or other item that the client is prepared to accept. And I'm going to point you to some resources a little bit later in the presentation. Definitely the trickier stuff, right? The provisions of Section 50 of the Planning Act are lengthy and complex, and contraventions are very serious. If a transfer, mortgage, or other dealing with the land does not comply with this section, it doesn't create or convey an interest in land. So because of this, we've seen significant, it's a significant source, this section, for malpractice claims. In my paper, there's a link to an article by Lisa Weinstein, who's VP TitlePLUS. It's a great article about the Planning Act, so definitely take a read of that. In Teraview, transfers include optional statements by the seller's lawyer and by you as the purchaser's lawyer with respect to compliance of Section 50 of the Planning Act. The effect of completing these statements in the transfer is that any prior contravention of the subdivision control provisions of the Planning Act, which would otherwise have the effect of voiding an interest in land, are deemed to no longer have this effect. So what do I mean by that? Previous violations of that section of the Planning Act will be validated. However, there are certain requirements that must be met in order for these statements to be signed. So make sure that if you can meet those requirements, sign those statements. Every CPD that you watch will have the same message: sign those Planning Act statements. But just to note, the statements are of no effect if you're acting for both the seller and the purchaser, even if it's permitted under the Law Society Rules of Professional Conduct. I'm going to spend a little bit of time talking about executions. So executions or writ searches are also conducted through Teraview. You should obtain a clear execution certificate against the registered owner for every deal, right? Because executions against a registered owner forms a lien on the property and must be dealt with before closing. You should obtain a clear execution certificate against the purchasers where there's a new mortgage going on title, and all mortgage guarantors unless the lender has expressly waived this requirement in writing. So any executions that show up must be dealt with before closing. It's prudent to search executions well before closing and also on the day of closing. So I want to, you see on my slide, I want to refer you to Land Titles Bulletin 2018-02. It's entitled Unintentionally Registering a Document Subject to Writs. Land Titles obviously sees this as a recurring problem, so they had to create a bulletin about it. So most commonly it happens in transfers. The situation happens when completing a writ search, you identify an existing writ of execution that can be cleared by one of the clearance statements. You manually enter the details on the writ tab and select the appropriate statement. Then you complete the rest of the document and it's completed and signed. On closing day, you submit for registration. Well, Teraview completes an automatic writ search and looks to see if the writ of execution are dealt with under the writs tab. If the manually entered information does not match the information from the Ministry of Attorney General's writ of execution database, the system won't recognize it as the same writ. It'll automatically remove that writ and replaces it with the information in the system from the Ministry's database. The clearing statements that you chose, those will also be removed. And then the system will default to subject to for the system retrieved number and writ. You will be provided a warning message indicating that the instrument is subject to this writ of execution. If you click OK to continue without paying attention to that warning message or reading it, the result will be that the transfer will be registered subject to that execution. Now, there are two ways to avoid this. It's set out in the bulletin. It's a really good one to pull and read. First, instead of selecting OK when that warning message comes up, select Cancel and return to the Writs tab and ensure that the appropriate statements are selected. Or two, use the Retrieve Writs feature in Teraview during the document creation and completion and the pre-closing writ cert instead of manually entering the writ information on the Writs tab. So documents registered unintentionally subject to a writ will not be returned for correctness. So you can after later on, if you do accidentally register it this way, you can fix it by registering an application to delete an execution. But like, why would you want to spend your time and your client's money trying to fix a problem which you can easily actually avoid by following one of the two steps and paying attention and not automatically clicking that OK message when it comes up when you're registering. So a note about off-title searches, they may be appropriate, such as there's tax, realty taxes, water, building, zoning, etc. After you've analyzed the file and you've done your title searches, discuss with the client and obtain any information on title searches that actually may be required, but you know, not necessary, not mandatory, but upon your analysis, you think, you know what, this is probably a good one, depending on what the client wants to do with the property. Always document all discussions. So again, at the outset of the retainer, it's really important to find out what your clients plan to do with the property. Most buyers will have some sort of intention, right? They'll either want to build a pool, or they want to do some renovations, or they might even rent out the property. So what if there's a subdivision development agreement that prevents it, or any restrictions due to zoning or easements? For example, renos might not be permitted under building code. So it's a good idea to have that discussion with your client. Include that question in your intake form as well. Do you have any future use that you intend for this property? So as I mentioned before, even where title insurance is being obtained, there may be some searches that, with instructions from your clients, you might want to complete even if the title insurer doesn't want it, right? So remember, title insurance is just a tool. It doesn't replace your due diligence. So I spoke briefly about requisitions. Ontario has a framework for the requisition process built into the Agreement of Purchase and Sale. It sets out the contractual obligations to deliver good and clear title. So requisitions is not just a means of communication between the lawyers, right? It's a process by which matters requiring attention, such as defects in title, are investigated and properly dealt with. Continuing malpractice claims highlight the requisitioning process as an important one in real estate conveyancing. You have a duty to ensure that your clients receive good and marketable title to the properties that they've contracted for. So as a purchaser's lawyer, if you fail to follow the requisitioning process, you jeopardize your client's position, right? Your client may not get good and marketable title. They may have to rectify a problem after closing, which could be costly and could have passed to the seller if it was properly investigated and requisitioned. Your client may lose the right not to close the deal, or lose the right to an abatement of purchase price. So you miss an opportunity to obtain important information that the seller may possess. Failure to requisition or late requisitions also sometimes show bad faith in some cases, and as I mentioned earlier, courts don't like purchaser's lawyer bringing things up at the last minute. Submitting all necessary requisitions in a timely manner may also reduce the likelihood of a negligence claim against you by the purchasers. Also, if you believe that an item is not going to be dealt with before closing or removed on closing, and you're thinking about an insure-over from the title insurer, definitely call them really early on in the as soon as you find out, to find out if there is some insure-over options for you. So we're going to talk about a little bit about mortgage financing. Now, most purchase transactions require mortgage financing, right? And as a purchaser's lawyer, you'll typically be acting for the purchasers as borrowers as well as the mortgage lender, if permitted under the rules of professional conduct. Let your clients know early on, this is going to be a bit of a recurring theme today, let them know early on that you need the lender's instructions as soon as possible, right? They may not understand the process. They have to gather all their personal information, attend at their chosen financial institution, sign the documents such as a mortgage commitment, and all of this takes time and should not be left to the last minute. So you can help minimize the stress and last-minute surprises by following up for the lender or the client to help move things along. I'm going to repeat myself here because it's important. In a purchase transaction, when you are acting for the borrower or lender, there is no confidentiality between them, and you owe a full fiduciary duty to both parties. Make the lender aware of any information, as I said before, that's material to their decision to advance the funds. And in fact, the rules of professional conduct speak directly to this under Rule 3.4-15. When a lawyer acts for both the borrower and the lender in a mortgage or loan transaction, the lawyer must disclose to the borrower and the lender all material information that is relevant to the transaction. The commentary, it's on my slide, but it does have some examples, and I'm going to talk about some of these examples later as well. So the mortgage instructions set out the terms of the mortgage as well as your obligations as the solicitor. Always read the mortgage package. It may comprise of solicitor's instructions, identification verification forms, preliminary reports on title, requests for funds, etc. Take note if the lender has any special instructions. Lender instructions and security documents are posted on the lender website, and they're subject to change without notice. So a lender won't let you know that their instructions have changed, and if you haven't acted for this lender in some time, it's a good idea to check what's on the website, but also look at it in conjunction with the instructions that they've actually sent you. Sometimes lenders have specific instructions about client ID and verification, which actually exceed the Law Society requirements, so be sure to follow them. Now, over the years, lenders' instructions have increased in scope, and lenders sometimes send unreasonable instructions to lawyers as well. The CBA became aware of this, and they created a mortgage instruction toolkit. It's a great resource. It includes practical tools to help deal with some common lender instruction requests in residential real estate transactions. The toolkit includes a cautionary note to lawyers. When responding to requests, limit the scope of your legal services to matters within your expertise, and restrict opinions to matters of law for which you conducted the due diligence, and do not give opinions on questions of fact. So review the mortgage commitment with the borrower clients and ensure they understand the terms of the loan and its implications. When things go wrong, borrowers often blame the lawyers for not explaining the nature of the mortgage, right? So how much they're borrowing, the interest rate, prepayment options, penalties, etc. It's really good practice to also document the terms of the mortgage in your reporting letter. Also make lenders and purchasers aware of priority issues. Some title matters will take priority, sometimes such as unpaid realty taxes, local improvement executions, as we spoke about, and unpaid condominium common expenses. So do not accept titles subject to these issues. If they are not paid or removed before closing, you should obtain the seller's lawyer's undertaking to pay them from the proceeds of closing. When the purchaser is arranging home insurance and you're waiting for that fire insurance binder, ensure that the name of the mortgagee is set out as a lost payee. Always keep a copy in your file. That's very important. So always have that in your checklist. Most lenders do require title insurance, so double check that if you have a pre-approved title insurance policy, that the lender is correctly named and the right endorsements are attached to the policy. So once the conditions of the mortgage have been fulfilled, request funds as soon as possible, and lenders sometimes like you to request funds 3 to 5 business days before closing. And I did want to point out there are actually many good online programs that are integrated with mortgages, and they help streamline the process, such as Lawyer Done Deal's Realty Web program. The integration, it saves you time, it minimizes the chance of error, and you'll be able to communicate with the lender electronically through a portal. You can seamlessly request funds, and you can also complete a report, a final report. So if you haven't had a look at one of those types of programs, it's a good idea to take a look. Cautionary note about private lenders. In most cases, you cannot act for both the private lender and borrower. That is under the rules of professional conduct. There are specific practice requirements set out in the Law Society's bylaw number 9, so take a look at that. The Law Society website also has some good guidelines under the practice management topics section, so if you haven't visited the website in a while, do take a look at that. So what is title insurance? It's an insurance policy for purchasers and mortgage lenders that provides compensation for losses suffered because of problems with title, survey, zoning, or other issues with the property, even if they're not discovered until years after the closing. So some of these issues can be unpredictable or undetectable, such as forgery, fraud, missing heirs, unregistered easements, or other problems such as construction liens, access rights, conflicting interest in the properties, etc. However, even though most residential properties in Ontario are title insured, it's actually not mandatory, and you do have an obligation to tell your client that they have 3 options to assure title in Ontario. 1, the lawyer's opinion on title. 2, traditional title insurance. And 3, TitlePLUS title insurance. So it's actually set out in the rules of professional conduct, and it's your duty to recommend the best choice for your clients. The commentary under that rule has some good information as well. I'm just going to point out some of the important aspects. Although title insurance is intended to protect the client against title risks, it is not a substitute for a lawyer's services in a real estate transaction. This also a recurring theme when it comes to title insurance. You're the expert, you're providing the client advice. The lawyer should be knowledgeable about title insurance and discuss with the client the advantages, conditions, and limitations of the various options and coverages. So as a purchaser's lawyer, you obtain title insurance for your purchaser or lender client. Typically, you will arrange for pre-approval before closing. And what happens is it's a title insurer and not you or the purchaser who assumes the risk of any matters covered under the policy. So if there are losses, pays compensation under the terms of the policy. Again, important to understand, it's just a tool, doesn't replace your due diligence. So it remains to be your role to protect the client's interests and make sure any issues are properly dealt with. In fact, depending on the issue, the client may actually prefer a search over the right to sort of claim on the title insurance policy at a later date. So important to review the coverages, standard exclusions, and specific exceptions in the policy and discuss it with your client. Under the rules of professional conduct, it's definitely recognized that it's the lawyer's role to do that. And I'm just going to read out an excerpt. A lawyer shall not permit a non-lawyer to provide advice to the client concerning any insurance, including title insurance, without supervision, right? So it's definitely recognized that it's your role as the lawyer. So with TitlePLUS coverage, the legal services that you provide as the lawyer in a purchase transaction are covered under the policy. So please refer to the policy, including actual terms and conditions. So now that I got that footnote out of the way, I get some brownie points back at work, right? I got some brownie points there. So if as part of your services, you make an error or you overlook something, example, you fail to register a document, remove an encumbrance, or incorrectly adjust an item on closing, the TitlePLUS policyholder, your client, can seek compensation directly from LAWPRO. And LAWPRO is the insurer for title insured properties. So in other words, an error will not result in a claim under your LAWPRO errors and omission policy. So I'll answer questions at the end of the presentation. Thanks. So Rule 3.2-9.7 of the Rules of Professional Conduct requires a lawyer to disclose to a client the relationship between the legal profession, the law society, and LAWPRO. So since we're on the topic of TitlePLUS insurance, did you know that we're the only wholly Canadian-owned title insurance product in Canada? We also don't charge extra for legal service coverage, and the purchaser and lender are both automatically covered under the same policy, residential commercial policy in Ontario. Plus, our customer service is pretty awesome. So give us a call. And as we see here, not all legal service coverage is the same. Our coverage explicitly covers losses resulting from the lawyer's negligence, regardless of whether or not it falls under one of the covered risks. So what this means is there are no circumstances in which a purchaser or lender protected by TitlePLUS policy should be forced to sue you if for a compensation for a loss suffered in relation to the transaction. Now, I do have to point out that most other title insurance providers don't cover all services provided by the lawyer. They only indirectly cover such lawyer's negligence if the result is a loss which is otherwise a covered risk. We don't have that. A note about private lenders. If you're acting for a private lender, some title insurance policies do have exceptions which may expose your lender client where there has been a fraud. So review the draft title insurance policy to ensure that it doesn't contain these exceptions that limit your client's coverage. If it does, advise your client of the additional risk they're assuming and document all discussions. There's also a link in my paper to an article that was published in our Avoid a Claim blog, which actually lists the types of exceptions that we were seeing. Now, this exception is not being added to the TitlePLUS policies as a matter of course, although TitlePLUS underwriting requires the lawyer to advise if the funds are going to parties that don't appear to be connected to the transaction in any way. Also, if you have questions about TitlePLUS underwriting, they're always happy to help you, so please call. Try and draft your closing documents as early on in the transaction as you can. I know that some lawyers will send draft documents with their requisition or initial letters to the seller's lawyer to review, so it's a really good idea that if you can get it done early on, go ahead and do that. The Working Group on Lawyers and Real Estate has created a set of standard closing documents which are available to use. These actually have been recently endorsed by FOLA, the Federation of Ontario Law Associations, so really they've recognized that these are really great resources. They're standardized closing documents. Use them, let your colleagues know, pass the message along. Some of the documents are a seller's closing certificate, a purchaser's undertaking and direction refunds. You'll have the lawyer's direction refunds, lawyer's undertaking, and a delayed closing escrow agreement as well. There's a user guide and a rationale document available on the website, and I'll tell you what the website is. It's www.lawyersworkinggroup.com, so definitely check that out. So as the purchaser's lawyer, you'll typically prepare a direction retitle, the land transfer tax affidavit, any mortgages where you act for the lender, and an undertaking to readjust. So a note about title. It's very important that this part of the transfer deed, A, is filled out, and B, filled out correctly, right? If the transfer deed is silent on capacity, it's deemed to be tenants in common. So if the purchasers, and typically if you have a husband and wife partners taking title as joint tenants, make sure it's filled out correctly because otherwise it will default to tenants in common. Leaving co-owners without capacity is actually one of the most common mistakes that we see, and it's really easily avoidable. Also, to the best of our knowledge, land titles will not do an administrative correction for this one. So do pay attention to that. As the purchaser's lawyer, you will also complete the Teraview acknowledgement and direction document. So it summarizes the terms of the transfer, the mortgage, and other documents, and provides a written record of the client's instructions concerning the delivery and registration of documents. So have the purchaser sign this before closing as well. There's a list of some typical seller's documents in my paper, and it does vary by jurisdiction, but you can take a look at that. So as you know, Teraview is used to access the electronic registration system and register documents. By now, you will have arranged to have an RSA token. So it's either going to be the key fob, which is the hard token, or the smartphone app, which is the soft token. Either one generates a code at fixed intervals, which you can use to securely log into Teraview. And Teraview on the web uses a two-step authentication process, the RSA code and your secure password, when you sign the electronic documents for completeness or release. So you can visit teraview.ca for more details. Again, if you can do it today, why leave it for tomorrow? Get into the habit of preparing Teraview documents in advance. So there are 4 types of documents. There's the transfer, deed of land, charge, mortgage of land, the discharge, and the document general, which is for all other registrations, and the schedule, if a schedule is to be attached to any documents. We spoke about the DRA a little bit earlier. Before closing, you'll sign it. It's stipulated in the agreement of purchase and sale. You're going to send it to the seller's lawyer. The DRA governs the relationship between the lawyers entering the DRA, and there's a link in my paper to the Law Society Practice Guidelines. It's Practice Guideline number 4. It's a really good resource to look at as well. So the DRA sets out the terms under which the funds will be held in escrow while any problems are being resolved. It also sets out who is responsible for the registration of documents, and items that require completion under the DRA can be actually set out in a letter as well. So confirming adherence to the DRA. So it's fine to adopt the DRA into your initial letter or requisition letter if that's your practice, fine to do that. So while some people adopt the DRA into their letter, they also say that documents will be exchanged via email, and it seems that that is fine as well. And the Law Society also now has a multi-party DRA on their website, so you can take a look at that as well. Immediately prior to registering the transfer and charge, you must complete a sub-search to ensure that there have been no intervening registrations or filings from the date of your last search, right? That's really important as well. And you'll only be able to register documents if both you and the seller's lawyer have signed for completeness and they've signed for release. So I don't know if you can see that, but the Teraview Electronic Registration Procedures Guide, it's a great resource. There's a link in my paper to that, and I've added screenshots of this guide just to show you how valuable it can be. And check out the table of contents. I'm not sure if you can see it from there, but it has, you know, how to complete a transfer, how to do discharges, and really a great resource. Take a look at all the information here. So really good idea to actually bookmark this page and really keep it handy as a resource. So as a tip, pay attention to detail when completing documents on Teraview. Sometimes errors will not be detected at submission, and therefore it will be sent back by Teranet staff. I don't know if you've had that happen to you, but it can cause undue delay. The registrar actually has 21 days to approve or reject documents that have been submitted for registration, so that is under the Land Titles Act. So you don't want a document to come back to haunt you 21 days after closing. So do pay attention to that. So I'm going to talk a little bit about pre-closing and day of closing. This really is the day that your clients will remember. So again, good to keep communication open with them. The closing will involve exchanging documents, funds, and keys. And a checklist, again, at this phase of the transaction is also very, very useful. There's so many things that you have to remember that if you can just check it off and refer to the checklist every now and then, it's a really good idea. If possible, although it's not a requirement, obtain oral confirmation from the utility and tax accounts to check for any arrears, and then communicate that with the seller's lawyer if needed. So as the purchaser's lawyer, you're going to be receiving the closing funds, deposit it into your trust account, draw funds according to the seller's direction. You'll also receive documentation and the keys from the seller's lawyer. You'll send your closing documentation to the seller's lawyer with the funds. And once they've received them, they will sign the transfer they will release the transfer for registration. You will then complete a sub-search to confirm that the last registered instrument is the same as your last earlier search, which I mentioned before. And if clear, you're going to register the transfer and mortgage simultaneously. Never register subject to executions or any unknown instruments that have come up, and pay close attention to registration priorities as well, right? So there's a transfer, first mortgage, second mortgage, and so forth. And remember what I said about executions. Read the land titles bulletin and don't just click on that OK button. Pay a little bit of attention to that too. Electronic funds transfer is becoming the norm, i.e. wire transfer to a lawyer's trust account or to a financial institution to pay off a mortgage. There are certain conditions that need to be met to withdraw money from a trust account by electronic transfer, and that is also set out in the Law Society's bylaw number 9. Immediately after closing, you're going to hand the keys over to the purchaser, probably the favorite part of your job. But also important is to convey some important and time-sensitive information at that point as well. For example, an upcoming mortgage payment or tax payment. Also good is to remind your clients at this time to call the tax department. And good practice also on that day is to provide a statement of account to your client. If there are funds in the trust account for fees or disbursements that you want to transfer into your general account, you actually can't transfer from a trust account to a general account unless you provided your clients with a statement of account, and that's under bylaw number 9 as well. Advise the tax and utility department of change of ownership. So do you have a cell phone? So what I mean by that is, you know, the purchasers are really busy that day, probably running around arranging for moving trucks or packing up, and they may not be near a landline or an office phone. So it's really important to make sure you have a cell phone handy, because issues can come up and you may need to contact your client to get instructions on how to proceed or make them aware of any issues. So a really good idea to make sure you have a cell phone, include that in your intake form as a reminder as well. So tying it all up, remember that big piece of the pie, 41% errors, communication. Well, completing a reporting letter as soon as possible also is part of tying up that communication process, right? It's a record of the transaction. It should contain all copies of relevant documents, including an issued title insurance policy. It should set out the details of the statement of adjustments, mortgage particulars, any responses to search letters that you received, how the purchasers took title, but especially if there have been any special instructions from the purchasers, or if you've advised them of a search that they waived, the consequences of waiving that search, document all of that. And don't forget your lender client as well. Include a copy of the registered mortgage and the title insurance policy if required. And in fact, it's stated under the rules of professional conduct that within 60 days of the registration of the mortgage, you should report to the lender. So I'm going to walk you through about some important practice information. In my paper, it's called Don't Skip Over These, because really, these are some really important factors as part of the real estate transaction as well. We'll start with client ID and verification. You must identify and verify the identification of your clients in accordance with Law Society Bylaw 7.1. So read the bylaw, it's part 3, and it also gives some information about if your clients are out of province or out of country. There's a great section on the Law Society's website under practice management topics, so take a look at that as well. The rules on client identification and verification are designed to assist in the prevention of fraud, money laundering, and terrorist financing. So this is a really important role that you play here. So definitely, take a note of that bylaw and follow it. Pay attention to lender instructions as well. Financial institutions do rely on lawyers to verify the ID of individuals as part of the closing process. Most home buyers, if they are getting a mortgage, and if it's not a private lender and you're acting for them, they will sign their mortgage documents in your office. And the lender's instructions may have changed from the last time you acted for this lender, so take a look at their instructions on the website as well. Again, I'm going to mention a document production and file management system. I mentioned Lawyer Done Deal's Realty Web program. It has checklists and reminders and a verification of identity. Sort of documents are generated for you based on your input. So it really makes it foolproof and easy to comply with the requirements if you use sort of an automatic system like that. An individual lawyer cannot act for both the purchaser and seller with respect to a transfer, except in certain circumstances, and only if the lawyer is able to comply with the rules of professional conduct regarding conflicts of interest. So the rule is 3.4-16.7, so take a look at that. The exceptions are set out in the rules, and they can assist you in choosing a box to electronically check to choose the right statement in the transfer. Right, my tightrope image. There's a reason why I chose the tightrope. You really are walking on a tightrope here. Delegation and supervision, the rules around these are very, very strict. It's your name on the retainer, it's your reputation on the line, and you are responsible for personally reviewing the whole transaction, the title searches, the off-title searches, and the title insurance policy to make sure that it's correct. So there are certain items which you can delegate, and there are certain items that you must complete yourself. It's also listed in the Rules of Professional Conduct and Bylaws 7.1. And I'm going to read an excerpt from the commentary for you. The lawyer must not assign to a non-lawyer employee the ultimate responsibility for review of a title search report or documents before signing or review and signing of a letter of requisition. Also, only a lawyer may sign for completeness of any document that requires compliance with law statements. Under the electronic registration of title documents, when a lawyer has a personalized security package, the lawyer shall not permit others, including a non-lawyer employee, to use the lawyer's personalized security package. So I've included the commentary in my paper. There's a lot of detail, actually, the commentary goes into with regards to E-Reg and the lawyer's responsibility, so I really encourage you to take a look at that. Just briefly about accounting, the practice management topic page of the Law Society's website has some great resources on this topic. There's a list of those resources in my paper as well, but it's all these the great resources that you have, private mortgages, how to open a trust account, fees, disbursements, HST, etc. So definitely take a look at that. A real estate CPD is not complete without discussing fraud. Fraud is getting more sophisticated. It's always evolving. We hear about it in the paper and the news all the time. You really have to be vigilant and mindful, not only about the existing frauds out there, but also about emerging trends. And train your staff as well. If you have staff, train them to watch for signs as well. Remember, the buck stops with you. It is, again, your reputation on the line. It's your name on the retainer. It really is your responsibility. And the value of real estate actually makes it really tempting as target for fraudsters as well. So if you believe that a transaction is at risk, don't hesitate to call the title insurer that you use and discuss it with the underwriter. They may be able to provide you with insights or ideas for further investigation, which will either satisfy your concern or indicate the probability that the fraud is high. The commentary under Rule 3.2-7.3 states, a lawyer representing any party in a real estate transaction should be vigilant in identifying the presence of red flags. Examples of red flags are in my paper. I'm going to be talking about a little bit about it later as well, but some of the items, sort of as an overview, is, again, purchase price manipulations, a nominal role for one of the parties, the purchaser contributes no funds towards the purchase price or any balance that's due on closing, suspicious or repeated third-party involvement, and the proceeds of sale are dispersed or directed to be paid to parties that are unrelated to the transaction. Also, in the practice resources section of the Law Society website, there are actually some fact scenarios, sample fact scenarios, which you can take a look at. The LAWPRO fraud fact sheet, also I'll be talking about that in a little bit. It's a great resource as well. So mortgage lenders are often the target of frauds as well. So again, keep the lender fully informed. I've spoken about that a couple of times already today. Again, disclose any information that you think is a red flag to the lender as well. So I'm going to be talking a little bit about the common types of real estate fraud. We're going to start with one of the really common ones, bad check fraud. And the scenario typically is that a new client will contact you, typically via email, and ask for legal assistance on closing a real estate deal, a purchase transaction. So this will involve them sending you a check, which you deposit into your trust account to obviously disperse funds from. However, the deal apparently goes south, it doesn't go through, and you're instructed to return the funds to the clients. Do not disperse those funds until the bank has confirmed that the check has cleared, because what's going to happen if it is a bad check, that it will bounce, the bank will send back the check to you, and if you've already dispersed funds from your trust account, it will leave you with a negative trust balance. So definitely pay attention to that. Identity theft. Fraudsters will use real-looking fake identity to impersonate the identity of an existing property owner, for example. They'll sell or mortgage the property, or will fraudulently discharge a mortgage already on title and then get a new mortgage from another lender. When the transaction closes, you pay the proceeds to the fraudster client, who then disappears with the funds. LAWPRO has also seen several attempts involving corporate identity theft. The properties involved may either be commercial or residential, but they'll always be owned by a corporation. So what the fraudsters do is they change or steal the identity of the corporate property owners by filing a Form 1 notice of change naming new directors or officers, or they may change the address of existing officers and directors in an annual return filing. So we've seen these types of corporate identity thefts as well. We've also seen fake Ontario driver's licenses, which look really real on a number of these frauds. For a nominal fee, I think it's like a $2.50 fee, you can check whether they're fake with a license number search on the Ministry of Transportation's website. So a value fraud or a flip fraud usually happens on a purchase or refinance deal. The client will say, that she or he is a real estate agent or in the business of buying and selling properties. They promise high fees, lots of business for a quick turnaround on deals. So those are some of the red flags. The title may show one or more transfers at increasing values. So the client typically will flip the property to an accomplice for a much higher value. And then the lender agrees to provide a mortgage based on the inflated property value. If the deal closes, the client may use the proceeds to pay the initial purchase price and then splits the excess funds with the accomplices. So the lender may get a valid mortgage, but has been duped into advancing much more than the real property value. So listen to your gut instinct. If something doesn't feel right, dig deeper and educate yourself and be familiar with the red flags, and I'll point you to some resources for that as well. So there's a bunch of links to resources in my paper for you. These are some of them as well. If you're a visual person like me, I've created these next slides just for you. So there's the Law Society's practice resources area. Take a look, especially under the practice area resources, there is a list under real estate law. So take a look at all the different resources that are available under this heading. There's the LAWPRO fraud fact sheet. There are details on bad checks, on bad check scams, real estate scams, and the red flags that you should watch for. The LAWPRO's real estate malpractice claims malpractice fact sheet, as well as a great resource. So we have some stats on there, some of the stats I showed you today already, but there's also some common malpractice errors that we see listed on this fact sheet, and also some risk management tips. So definitely take a look at that as well. The link is in my paper. So a nice big screenshot of the Avoid a Claim blog. I really suggest that you subscribe to the Avoid a Claim blog. We post upcoming frauds and other really useful articles, and then if you subscribe, then you'll get an email notification that you can go and check those as well. On Avoid a Claim, you can also search names of if there's a deal that's come through the door and the name and the deal looks suspicious to you, you can actually do a search of that name. And on the Avoid a Claim blog, and details of that fraud, including pictures of their fraudulent documents or even the fraud, the bad checks, will be on the Avoid a Claim blog as well. So definitely take a look at that. And as you see, I've highlighted the all fraud warning section, and there's a section for real estate as well. So take a look at that. Then there's our Practice Pro website. Again, has a lot of useful resources for you. As you can see, there are checklists and new lawyer resources as well. So definitely bookmark that page. We post the LAWPRO webzines and magazines and other articles on this website as well, so take a look at that. I mentioned the working group. On Lawyers and Real Estate website as well. They have some really great standard documents that you can look at. I also pointed you to the Teraview Electronic Registration Procedures Guide, and that's a great one as well. And of course, my file management checklist at the end of the paper. Again, use it, make it your own, and pass it along as well. So staying organized and keeping communication between you and your client open, not just at the outset of the retainer, but throughout the transaction, will really help manage your risk and also enable really effective communication with the clients. It will help keep things on track and the deal moving along nicely, especially if you have a number of deals closing on the same day. So you can definitely reduce the risk of a malpractice claim. Take a look at the resources, read the paper at your time as well. I know that our consultants are really happy to come and visit you in your offices. You just have to give us a call. And you can follow us on Twitter, TitlePLUS Canada, and connect with us on LAWPRO LinkedIn as well. So at this point, I will take some questions, and I guess there's one that came in through the webcast. So how to recognize a fake ID? That is definitely, it's a tricky one because they do look so real. I guess along with trying to recognize the fake ID, you need to sort of be aware of the red flags that comes with the deal. So some of the red flags I already pointed out, some scenarios that I pointed out. So if the deal sort of falls within that scenario, that certainly points to something not quite being right. Also, I pointed to some resources. You can check out the Ministry of Transportation website if there's a license that comes in and they'll look really real. Do a quick license check. Again, I think it's to be really mindful of the red flags. That's really going to help you figure out if there's something not quite right with the deal. Also, when would the multi-party DRA be used? So the multi-DRA could be used in a situation where you're acting as the purchaser's lawyer, excuse me, and there's a seller's lawyer, and then there's also a private lender, which a private lender has to have their own lawyer, right? So, so there are now 3 parties involved, and the multi-party DRA will be useful in that situation. So are there any other questions? Go ahead.
I actually have 2. So is where there's private funds being loaned from an RSP, for example, and but it's an institution on title, like Canadian Western Trust or something like that, is it considered a private mortgage?
If it's an institution, if it's like a credit union or something like that?
So for example, you can lend money from your RSP, but it'll say, for example, Canada Trust Company or Canadian Western Trust. Is that considered a private mortgage for the purposes of that rule?
So the question is, if there's money being, just in case people on the webcast can't hear, if there's money being lent through an RSP, for example, through Canadian Western Trust, would that be considered a private lender? Do you know what? That's a really good question, and I'm afraid to say yes or no without actually digging a little bit further, so I will check the answer for you for that one.
It like it was, but I've never been able to find the answer.
So have you considered calling the Law Society's practice advisory? They weren't sure? Okay, so you know what? Let's look into that a little bit. That's a really good question. Let's look into that a little bit, and I will get back to you on that.
Okay, and then my second question is, I always just give the vendor's clothing certificate, but some lawyers are really insistent on getting certain statements in statutory declaration form. So for example, non-resident, it has to be in statutory form. For the purposes of the coverage under the policy, does it make a difference? I suspect no, but...
So for the purposes of coverage under TitlePLUS policy, for example?
Right, so if the vendor gives a declaration, or a statement in the vendor's clothing certificate that says, I'm not a non-resident, turns out that they are, for the purposes of coverage under the TitlePLUS policy, does anything turn on whether it's in statutory declaration form or whether that statement comes in the traditional or in the new vendor's clothing?
Okay, so I'm going to go out on a limb here and say it shouldn't matter as long as you have something in writing, signed off, and you know. However, again, I can't really talk about coverage issues and what's covered and what's not. So this also is something that we should probably talk to our TitlePLUS underwriting counsel about, and we could talk about that offline as well. Great questions. Any other questions? Okay, well, it's a wrap. So have a great day, everybody, and thanks for joining us on webcast as well.